Good evening to everyone present here. Respected Professor Maxwell Stearn, Veneable Baejter and Howard Professor of Law at the University of Maryland, Carey School of Law. Respected academicians from different universities and students. I, Soumya Thakur from Maharashtra National Law University, Aurangabad, take immense pleasure in welcoming you all for a webinar on economic analysis and the premises of contract and tort doctrine by Professor Maxwell Stearn. Professor Stearn, Veneable Baejter and Howard Professor of Law at the University of Maryland Carey School of Law, is an interdisciplinary scholar. He applies the methodologies of economics, broadly defined, to study private and public law, along with institutional decision-making process. Professor Stearn joined the faculty at Maryland Carey Law in the fall 2006. Professor Stearn previously had been Professor of Law at George Mason University School of Law since 1992. Professor earned his BA from the University of Pennsylvania and his JD from the University of Virginia. Professor served as an Associate Dean for Research and Faculty Development from 2013 to 2017. His work combines such tools as neoclassical economics, interest group theory, social choice, and game theory, among others, to study legal doctrines and lawmaking system. Much of his work concerns on structural aspects of constitutional decision-making in the Supreme Court, along with such specific doctrines as standing, the common clause, and equal protection. His most recent book, Law and Economics Private and Public, comprehensively applies a broad range of economic methodologies to subject matters across the law school curriculum. The book surveys the first-year courses along with many upper-level subjects, and it embraces both private and public legal domain. Trials and case outcomes in the Supreme Court. Professor Stearn scholarly articles appears in leading academic journals: Yale Law Journal, University of Pennsylvania Law Review, California Law Review, Stanford Law Review, Georgetown Law Journal, Notre Dame Law Review, Vanderbilt Law Review, and the University of Pennsylvania Journal of Constitutional Law. During the COVID pandemic, Professor Stearn created and he continues to run the virtual Constitutional Law and Economics Workshop, bringing together leading interdisciplinary scholars throughout the United States, Europe, and the Middle East. On behalf of Maharashtra National Law University, Aurangabad fraternity, we welcome you, sir.
Thank you.
Thank you so much, sir. Thank you so much. The session will be followed by question and answer. Sir, am I audible to you?
You're audible to me. The video is kind of going in and out.
Okay,
I can now see you, and now I can't hear you, but I can see you.
Okay, sir.
Now I can hear you.
Okay, sir. Okay, sir.
No worries. Can you see and hear me?
Yes, sir. Yes, sir.
Very good. Are you ready for me to begin? I don't want to cut you off. You've been so wonderfully generous in your introduction.
Thank you so much, sir. Just, uh, just a little bit. The session will be followed by question and answer, for which the participants can use the question and answer section to pose their queries. The question and answer session will be moderated by Ms. Soumya Raj Singh, Assistant Professor of Law at MNLUA Aurangabad, followed by vote of thanks by Ms. Neha Tripathi, Assistant Professor of Law at MNLUA Aurangabad. With this, I would now request Professor Max to kindly address the participants.
So thank you so very much for that incredibly generous introduction. I want to thank everybody at Maharashtra National Law University and everybody who's attending from wherever you happen to be, viewing this remotely. I want to thank Professor Neha Tripathi, Soumya Rajsen, Soumya Kakul. Hopefully I haven't terribly mispronounced your names. It's just a delight. It's just a delight to be here, and I really do appreciate your giving me this opportunity. I am suddenly experiencing a strange technical problem. We had done the share screen, and for some reason now it's giving me a challenge. There we go. Very good. Okay. I wanted to be sure that I could share properly. I'm hoping everybody can see the screen.
Yes, sir, you're visible properly, sir. Audible.
You can see it. Very good. Okay. Well, it's absolutely wonderful to be here, and I hope that my audio feed and my video work throughout. So today, I'm going to be addressing the topic of the economic analysis of law in the premises of contract and tort. And I'll start with the thesis of my talk. The thesis is that economic analysis helps to identify the foundational premises of common law doctrines. And in doing so, it provides the basis for a positive account, an explanatory analysis, if you will, of such bodies of law as tort, contract, and property. Today, I'm primarily going to be focusing on tort and contract, but I will be mentioning some property concepts as well. I hope to show that a few foundational economic insights provide the basis for a deeper or better understanding of these important bodies of case law. I'm going to rely on two central observations. One is that of pure Nash equilibrium drawn from game theory. The other one is the Coase theorem, which is drawn from the neoclassical economic analysis of law. So a pure Nash equilibrium has three components to it, and it represents an outcome or set of outcomes based on each player's, or singular or plural, each player's rational strategy or strategies in the absence of specific knowledge of the other players, again, singular or plural, specific strategy or strategies based on the anticipated rational behavior of the other player or players, and finally, from which no player can improve her or his position with a unilateral change in strategy. And I understand for those who have not had exposure to game theory, that sounds terribly daunting. And please bear with me, because I think I can make these concepts that I'll be introducing more familiar with examples. So please don't be intimidated by the kind of theoretical level of abstraction of that definition. I'm going to give illustrations from three fairly common games. One, the prisoner's dilemma. Second, the driver's game. And the third is the battle of the sexes. And I'm going to demonstrate that in the prisoner's dilemma, the pure Nash equilibrium is mutual defection. In the driver's game, it is having the drivers drive on the same side of the road to coordinate the behavior. And in the battle of the sexes, it's coalescing on either partner's first choice. And I'm going to illustrate this now. This is maybe the most famous game. It's the one that even people who have really never had much exposure to formal game theory tend to be somewhat familiar with, even from television shows. So this is the classic prisoner's dilemma. And you can imagine the police arresting two collaborators in a criminal activity, Alex and Brad, in saying to them the following in separate rooms. So these two are separately placed, and the police address them each as individuals. And the officer says to them, if you both cooperate, and let me specify, cooperation means Alex and Brad are cooperating with each other, not with the police. Defection means that they are cooperating with the police. But for purposes of the game, cooperation means that they're cooperating with each other. And defection means that they are undermining each other. So if you both cooperate with each other, we're going to only be able to get you on a relatively modest misdemeanor. You'll each serve 6 months in prison. If you each rat each other out, so you defect, we're going to get you on a more serious felony. You're each going to likely spend 3 years in prison. If one of you cooperates, if one of you is silent, but the other one rats the other out, the one who is the rat will be rewarded for the cooperation. That person will get to walk, no time at all. But the one who has been cooperative with you, who remains silent, is going to get the maximum sentence of 5 years. And what we discover with this game is that, let's assume in the top row, Alex cooperates. The payoffs are Alex and then Brad. If Brad also cooperates, Brad is going to get a 6-month sentence. But if Brad defects, he's going to get no time at all. So he has an incentive to defect if Brad cooperates. Conversely, if Alex defects and if Brad cooperates, Brad's going to be facing 5 years in prison. But if Brad also defects, that sentence goes down to 3 years. These incentives are reciprocal. You can do the same thing based on Brad cooperating or defecting and then following through on Alex's strategy. But the pure Nash equilibrium arises because whatever the other player does, it is rational for each player to defect, resulting in the payoff of 3 years and 3 years in the lower right, notwithstanding that if both of the players cooperated, each of them would receive a lower sentence of 6 months each. And that's the classic prisoner's dilemma. So the pure Nash equilibrium is a singular outcome of the lower right with mutual defection. By contrast, in the driving game, imagine a situation at the advent of automotive vehicles, before there are formal rules of the road, sort of in the early part of the 20th century. And you can imagine a community in which there are two purchasers of cars, obviously well-to-do, and they have no rules of the road, and they're trying to each anticipate what the other driver will do. And they have a chance of getting it right and a chance of getting it wrong, 50% each. If A and B are two drivers, correctly anticipate that each other driver will drive left, or if they correctly anticipate that the other driver will drive right, then they arrive at the pure Nash equilibrium of coordinated driving, in which they substantially lower the risk of colliding on the road. By contrast, if one of them guesses wrong such that A is driving left and B is driving right, or vice versa, B is driving left and A is driving right, that substantially increases the risk of a collision. And so you see, again, you see the bolding of the pure Nash equilibrium. In this game, there are two pure Nash equilibria. And in fact, we see this throughout the world. In the United States, we drive on the right. In the UK, they drive on the left. I apologize. I should know where you're driving in India. And I assume it's the UK rule. But it doesn't matter which side you're on. It only matters that everybody is coordinated around the same side of the road. The third game that I'll introduce is called the Battle of the Sexes. This is a very interesting game. It's a game in which we have a couple, a husband and a wife, and it's actually an optimistic couple or story. They're genuinely in love. They seem to like each other's company, but they don't have the first choice of activities. In this example, the wife really prefers to go to the football game, and the husband prefers to go to the theater. And despite their differences in activities, they're in love. That's a wonderful thing. And they prefer to go even to the other spouse's activity together to going to a first choice activity alone. And what you can see in the payoffs is that if the husband and wife join at the husband's first choice activity, the theater, the husband earns the highest payoff of 10, the wife earns the second highest payoff of 7. Reciprocally, if the husband and wife join the wife's first choice activity at football, the wife gets the highest payoff of 10 and the husband a 7. If each goes to their first choice activity alone in the upper right, they each get a lower payoff of 5, although that's still higher than if each goes to the other's first choice activity alone, maybe trying to create a surprise or some such thing, in which case each gets a payoff of 3. And here you'll notice again that there are 2 pure Nash equilibrium. They're represented in the upper left and in the lower right. The battle of the sexes game is a nice game to think about in the context of contract law. If you've ever heard the admonition in contract that it is more important to have a clear rule than the right rule, you can correlate that to the notion of the battle of the sexes in some ways. And I'll be talking a little bit more about contract law fairly soon. So now I want to get to the question of the premises of the respective doctrines of tort and contract. The premise of tort law, I will suggest, is minimizing the sum of accident costs, including precaution costs and expected damages that arise as a consequence of accidents giving rise to tort. Regardless of the tort regime, in equilibrium, prospective tortfeasors and victims will engage only in the cost-effective precautions. They're not going to engage in precautions that are not cost-effective, but they will engage in cost-effective precautions. The choice of regime does not affect the precaution level. Instead, it affects only the allocation of what I'll refer to as residual risk. Residual risk is the risk that remains after each party, the tortfeasor and the tort victim, take cost-effective precautions. And the allocation of residual risk is a fairness rather than an efficiency consideration. So let me illustrate this graphically. This is a very simple graph that derives from the work of Professor John Brown, who wrote about this in the early 70s and came up with a theory that I've just articulated. And this presents it in kind of a single visual. So we have 2 axes. We have the vertical axis, or the y-axis, representing expenditures, here represented in dollars, and the horizontal axis, or the x-axis, representing the level of care, for example, that a tortfeasor or a tort victim may undertake. And you'll see that there are 2 curves that rest beneath a summary curve. So the X curve rises at a constant rate, and that curve represents the cost of additional precautions. And simply for heuristic presentation reasons, we are assuming that those costs rise at a constant rate. Each additional precaution costs a sort of steady increase in the price that can be predicted in this very upward sloping graphic. So X represents the costs of additional precautions. ED represents the expected damages in the event that an accident gives rise to tort liability. And you'll see that this curve is downward sloping as a function of the level of care that the party invests in. And I don't want to get too technical, but you can see that over time it will asymptotically approach the horizontal axis. Now you'll notice the curve above, X plus ED. That's a summary, or rather a summing, I should say, of these 2 cost curves. And the goal of tort law, as I suggested in the prior slide, is to minimize the total cost of accidents, which means minimizing the sum of precautions plus expected damages. So you want to get to the lowest point in that U-shaped curve, X plus ED. Notice that the lowest point in the X plus ED curve does not coincide with the intersection point of X and ED independently. That's because those curves represent total cost, not marginal cost. And in my book, I explore that in some more depth. But the idea is that what we're trying to do is minimize the sum of these precautions of the total accident costs. And what we discover in John Brown's theory is rather stunning. We discover that the parties are going to be motivated to invest just up to the point of X star, which is the level of cost-effective precautions, the point at which the marginal cost of the next precaution equals or exceeds or just slightly exceeds the marginal benefit of that precaution. This is more clear in this slide, which is the same, except I'm bolding here the cost that the tortfeasor is expected to incur. And what you can see is that up until the point of X star, the tortfeasor anticipates incurring the sum cost both of the precautions undertaken and the expected damages. But once we get past the point of X star, the only thing that the tortfeasor expects to incur in equilibrium is the cost of precautions, because at that point, having taken cost-effective precautions, the tortfeasor no longer is going to be facing expected damages because the tortfeasor has satisfied the legal obligation. And one of the things that you'll see here is that although this provides a very strong incentive to invest up to the point of X star, but no further, if you invest beyond X star, you may be spending $1.25 in the next precaution, but only getting $1 in the marginal benefit, $1.25 marginal cost, getting $1 marginal benefit. You may go to the open market and insure, for example, or you may self-insure. It'll be cheaper than engaging in that next precaution. And so again, what this demonstrates is that the incentive is to invest up to X star, but not past X star. Nonetheless, even if we apply this graphic both to the tortfeasor and the tort victim, there is what is referred to as residual risk. In other words, everybody engaging in cost-effective precautions doesn't eliminate risks, but it reduces risks to the risk that remains that's unavoidable, called residual risk. In the tort regime, really secondarily is about the allocation of residual risk. Under negligence or contributory negligence, the residual risk falls on the victim. Under strict liability or strict liability with contributory negligence, the residual risk falls on the tortfeasor. Under comparative fault, which is dominant now in the United States, the residual risk is shared based on relative allocations of ascribed fault. So that provides kind of a basis of the overview of tort law using a very simple tool of pure Nash equilibrium to demonstrate the premise. And the premise is to minimize the sum of accident costs, including precautions and expected damages, and the effect with respect to the allocation of residual risk. I'm now going to turn my attention to the Coase theorem and to contract doctrine. The Coase theorem, many of you are likely familiar with if you've studied contracts or torts, perhaps. This is something that does often get included in the curriculum. And the Coase theorem can be expressed fairly simply, although it's another concept that really benefits from an application, which I'll give in a moment. In a world with zero transactions costs and perfect information, resources will flow to their most highly valued uses without regard to liability rules. In a world with zero transactions costs and perfect information, resources will flow to their most highly valued uses without regard to liability rules. By way of illustration, if you have a factory that is worth $11,000 polluting into a river to the detriment of a laundry, and you have a laundry that's worth $40,000, if the factory's shut down and not engaging in pollution, but only worth $24,000 if the factory does operate and does pollute. The question then is, well, what are the private market dynamics that will affect whether the factory does or does not run? And let me just be clear, these dollar valuations obviously are arbitrary, but the one thing that is important if you're going to think about this is that the timeline be consistent. So it doesn't matter whether these are values weekly, monthly, annually, it doesn't matter, but it does matter that we have the same period for these valuations for both the factory and the laundry. We have to have internal consistency. So if the laundry has the property right to enjoin the factory because of the pollution, the factory is not going to be able to pay the laundry to remain open because the factory isn't worth enough money to accommodate the difference in value to the laundry. The laundry is suffering at $16,000, but the factory is only worth $11,000. The factory can't buy its way back into opening. By contrast, if the factory has the right to continue operating, the laundry will pay it to shut down because the difference in value to the laundry of $16,000 exceeds the operating value of the factory at $11,000, producing essentially a $5,000 gain that the two parties can allocate between them through bilateral negotiations. So this brings us a nice opportunity to think about the contract law premise. Contract law promotes social welfare, by which I mean it creates societal wealth that the parties can share. It does not ensure that promises are kept. And that's counterintuitive to a good many law students and maybe even to some lawyers to think about that contract law is about promoting social welfare, not ensuring that promises are kept. How does contract law do this? It does this by providing default or off-the-rack rules that facilitate social welfare, wealth creation, enhancing the gains that the parties are able to allocate between them. This aligns with the Kosian insight that I've just gone through, revealing that contract law lowers transactions costs, thereby promoting private agreements that help to move resources to their more highly valued uses, again, consistent with the Coase theorem. So how do we know that what I've just said is true? Well, the biggest sort of signal is that the default damages rule in common law contract is expectancy damages. Expectancy damages restores the victim of a contract breach to the position the victim would be in had the breaching party fully performed. That allows the breaching party to compensate the non-breaching party and to retain the gains after doing so as a result of the superior economic activity or opportunity that motivated the breach. And we can compare this with a couple of other contract remedies, which I will do, specific performance and also liquidated damages, and I'll get to that in a moment. So we'll start with this illustration. Let's assume that we have a table manufacturer, T, and T contracts to sell a rosewood table for $5,000, and the wood costs $1,000. The production expenses for the table are $2,000, and the buyer, B, plans to resell that table after buying it for $5,000, retail at $7,000, so the buyer expects a $2,000 gain. Assume that a guitar maker happens into T's warehouse and sees this piece of wood and realizes that this piece of wood possesses a rare quality that would allow its use in the construction of a musical instrument that the guitar maker, G, knows would be valued at $25,000. So she offers T $8,000 for that piece of wood. Under expectancy damages, if T breaches the contract with B, T is going to owe B $2,000, which is $7,000 minus the $5,000, $7,000 that B is going to sell the table for minus the $5,000 that B pays for the table, placing B in the same position as if T had performed. After the payout, T comes out pretty far ahead by $5,000. How do we get to that number? Well, T gets $8,000 for the piece of wood, minus the $1,000 that T paid for that wood, minus the $2,000 paid in damages to B. Of course, T doesn't have to incur the $2,000 production cost. So it's $8,000 minus $3,000, which is $5,000. So that's pretty good. That's improving social welfare to the tune of $5,000. So we've come up with a solution. But at the same time, we've kind of come up with a puzzle, and here it is. It illustrates the Coase theorem in as much as we would end up with a social welfare maximizing result, namely T selling that piece of wood to the guitar manufacturer, not to the table buyer. Even if the rule were otherwise, if T were obligated to perform, that $5,000 superadditive gain would encourage a negotiation between T and B. They would share those gains that would result still in T breaching the contract. That piece of wood's going to go to the guitar manufacturer no matter what. But under the expectancy damages rule, T's keeping all the gains. So here's the puzzle. B is the good guy here, right? B didn't do anything wrong. B entered into a contract that was breached. And T, the breaching party, is arguably the bad guy here. So why not force the sharing of T's gains by insisting on specific performance? And if you did that, well, you'd force T to the bargaining table. And we can assume T has one. Well, this alternative solution risks depleting that $5,000 super additive gain through negotiations, or what we can call rent dissipation, as to their allocations. Bilateral monopoly bargaining is prone to the dissipation of resources in bargaining. You can model this, and I've done this in other settings, in multilateral negotiations, which invites other kinds of games, including empty core bargaining or cycling games, but I'm not going to get into that in this talk. But the basic idea is that the expectancy damages rule, although it allows the breaching party to keep the gains, promotes social welfare while reducing the risk of depleting assets through these forms of negotiation, which suggests the contract law generally isn't concerned about how gains are allocated through contractual bargaining at the front end. But on the other hand, contract law is sometimes concerned with strategic behavior at the back end. Strategic bargaining arises when a contracting party seeks to take onto herself or himself gains originally intended for the other party at the time of contracting as a result of an opportunity arising once the other party has invested in performance, and at which point exit is more costly than incurring those unanticipated costs taking the form of a modified contract. In the United States, this is reflected in the Restatement Second of Contract, Section 89, having to do with permissible versus impermissible contract modification. There are two very famous cases on this, Alaska Packers versus Domenico, which involves an ice supply contract, and Goebel versus Lynn, which involves a fishing crew contract. I'm not going to get into the details of that here, but I did want to flag it for you. I also want to talk about liquidated damages, and here I'm going to compare the US rule versus the rule in Germany, which I think is better. Germany permits penalty clauses, which you could think of as an extreme version of liquidated damages. The US generally disallows liquidated damages, except when they represent a fair estimate of expected damages. I think Germany's got the better rule here from the perspective of improving social welfare. Why is that? Liquidated damages clauses are especially helpful precisely when the promisee, the person to whom the promise is made, holds a higher subjective performance valuation for the promisor's performance, meaning when the award would exceed the market value of expected damages. And this is a famous US case. Every contracts book uses it, or property book uses it to illustrate this proposition. The Peavy houses were a family who owned a farm in Oklahoma that they leased out for 5 years for a coal strip mining operation. The leasing contract called upon the mining company to restore the land to its original condition once the strip mining operation was complete. But when the time came for the restoration, the mining company balked. The restoration cost was estimated, and bear in mind, these are $1960, was estimated at $29,000. But the difference in the fair market value to the home was fairly trivial, estimated at a mere $300. The claimants were ultimately awarded $300, with a dissent calling for specific performance. If you want to see just how bad this is a picture of the farm, and then to the northeast, you see the strip mining that they now have to look at every day, and to the southeast, you see damage from the flooded mine that they also have to look at every day. Not a pretty picture. There was no liquidated damages clause, meaning that there was simply a breach performance obligation. But because the Peavy houses fully intended to remain on the farm, which was their home, they almost certainly held a higher subjective performance valuation than the trivial diminution, $300 in fair market value associated with the award. But consider a $50,000 liquidated damages clause, which would exceed the $29,000 performance cost. Under U.S. law, this would not be enforceable. But if it were, the mining company would have performed. And that clause would have let the PV houses signal that they have a higher subjective performance valuation above the $29,000, and disallowing that clause undermines the ability of that contract to promote social welfare. It's interesting to note that a vote of U.S. law professors in 2008 deemed the PV houses the most poorly treated claimants in America, and that proves that not every contest is necessarily worth winning. Well, here's a possible way out even with the U.S. rule. Imagine taking a two contracts approach. Contract one is for the strip mining operation, but we subtract from the payoff $15,000, which is less than the $29,000. Contract two is a restoration contract for $15,000, which is less than the $29,000 for the restoration cost. Contract two, unlike a liquidated damages clause, is apt to be upheld within the U.S. United States courts generally award expectancy damages without independently assessing contract valuation, for example, based on differences in fair market value. So imagine I hire a painter to paint my White House chartreuse, right? And that the painter breaches. The painter is going to be liable for the cost of cover, my finding another painter to paint my house chartreuse, despite the fact that that choice maybe would undermine rather than improve the fair market value of my home. Likewise, the strip mining contractor would be bound to cover the difference between the $29,000 and $15,000 price, $14,000, assuming that the $15,000 hadn't been paid, which would make the PV houses whole. And this aligns a property premise with contract. It lets us promote social welfare, including ensuring that contracts improve the value of the homes that we live in, matching what we subjectively value, not merely fair market value. And I think that that's really important. We wouldn't want to live in a world in which the only improvements that are rationally to undertake are ones that the market values equally with us, right? People think of economics sometimes as a cold discipline, but here economics is actually suggesting a personal value being honored in the law for reasons we can identify with these tools. So some concluding thoughts. Basic tools of game theory and neoclassical economic theory help to uncover important foundations across two bodies of common law, tort and contract. More broadly, economic analysis, including price theory, interest group theory, social choice, and game theory, helps to unmask premises across a host of legal domains. This holds not only in private law, like what we've been talking about this morning, but also public law, including constitutional law, administrative law, civil procedure, criminal law, and criminal procedure. And so acquiring a basic foundation in these analytical tools promises to enrich your legal education or knowledge for those of you who are professors or lawyers by offering a more robust set of framings across cases, doctrines, and courses. Here are some of the sources that I relied upon in my remarks, and I'm now done. And what I'll do is I'll stop the screen share so that I can entertain whatever questions you may have. And thank you all very much for joining me this morning. It really is quite an honor to be here.
Soumya,
Yep.
Thank you so much, Professor, especially the kind of insight you have given. It's really something which is very new to all of us. And I think the takeaway point would be that I think along with me, rest of my co-participant would be taking that contract is the motto of a contract is social welfare. It's not promises to be kept. I think I just done my completed my law. It's not that much that long. I completed my law schools like in this decade only. I have been taught with that idea that it's basically something that you keep promises, and the social welfare quotient of contract is really something new and commanding. Indeed, it was a very insightful discussion, and we have plethoras of questions. And I would be briefing you a little before me reading out the questions. We would be sending the questions to you in writing. You can read it in the chat box sections, and then along with that, I would be reading the questions too. The first questions would be, Professor, from my side that, I do understand the technicalities that you were talking about, but we cannot deny that the economic analysis of an issue does not take place in vacuum. It did depend on the other social and political and institutional setup of a country. Whether to call a tort a wrongful act, and what act would be called as a tort, or with the act as a crime or not. In that kind of considerations is there. In particular, law and economics analyze or conform with political institutions, moral norms, social conventions, and widely shared belief about the rights and obligations of the member of the society. So overall, we can say that the legal and political structure of a society conditioned the results of the analysis of law and economics. In that background, let me allow you to throw some light on the area that, how will a society's willingness and unwillingness to draw distinction among people based on particular characteristics affect the choice of a liability rule of that society? That would be precisely my question, and I would definitely now want to throw some light on that.
Thank you for that. That's a very thoughtful question. It's interesting that you asked it, in part because my staple course that I teach, the doctrinal course that I teach in the United States, is constitutional law. I'm an unusual professor that way. I teach constitutional law, including equal protection doctrine, which touches on the kinds of issues that you're describing. I also happen to teach law and economics. And so you're asking me to move from one side of my brain to the other, which I'm very happy to do. But there's a connection between them, right? It's very interesting. I was teaching constitutional law yesterday, as a matter of fact, and I pointed out to my students an economic insight. And I said to them, when we're thinking about class divisions, for example, or sort of hierarchical treatments of classes, which in the U.S., at least in theory, we've gotten past, although in practice there's ample examples of racism, genderism, other kinds of privileges that majority groups tend to benefit from, and others obviously suffer from not being in the majority group, even if they're not formally sanctioned. And there's a very complex body of case law in the United States involving what we refer to as benign race-based or gender-based preferences. In other words, we have a series of cases, which is really part of what I teach, having to do with a set of doctrines called affirmative action that are designed in large part to recognize adverse historical treatments of marginalized groups that have been historically treated in disadvantageous ways. And that invites its own separate set of analytical tools, not the tools that I've used today. I want to be clear that the tools that I've used today really are limited to trying to understand in a kind of positive way, meaning an explanatory way, the structure and formation of tort and contract doctrine. It's not designed to make a normative argument about other aspects of the role of government in seeking to overcome past adverse treatment of disadvantaged or marginalized communities, whether based on race, religion, or some other, or gender, or some other demographic consideration. Those are really important questions having to do with public law. And as I said, and I think at the very last slide, that there are tools of economics that I think can help to study those public law domains. But I do want to be clear, I don't want to be overreaching. The talk that I gave today was not an attempt to do that. So, you know, I don't know if that quite answers if that quite answers your question. If it doesn't, please follow up, because I want to be sure to be responsive.
Thank you very much, sir. That precisely gave an idea, insightful idea that obviously going to help us to research more in this aspect as well. We have another interesting question that reads as it is like, in an accident, there are joint tortfeasor at that time. Who will be liable and how would be the test? In an accident, there can be a joint tortfeasor as well. In that circumstances, who would be liable and what would be the test to hold the liability?
Yeah, it's a very good question, and it's very complex because it depends upon. So in the United States, I maybe should have said this earlier, and I'm glad I have a chance to say it now. I want to be clear. There's not a national law on tort doctrine. We have a federalist system, and each state has its own tort rules. So the tort rules in my state, Maryland, are different from the tort rules in Virginia. In a adjoining state. Actually, it's quite striking. We have an outlier rule in Maryland, where I live. We have negligence with contributory negligence. The consequence of which is that if the plaintiff is negligent, the tortfeasor is exempted from liability. Now, that's a little bit oversimplified. Whereas the majority of United States state jurisdictions have comparative fault, which allocates the burdens between the plaintiff and the tortfeasor in the event that both parties are at some level at fault. But the question, as I understand it, was slightly different but related, having to do with multiple tortfeasors. And that's a really interesting question. So there are different ways to allocate that. It depends on the state rules, but in some instances, you'll allocate it based upon degrees of contribution to the accident, if that can be ascertained. And that will often be a fact-finding question for the jury to allocate. But there's also a set of cases in the United States that are quite fascinating, involving lead paint, where there were communities throughout the United States that were where the houses were painted with lead as a component of the paint, and those companies didn't keep records of the homes that they painted, and the homeowners don't have records of which particular paint brands were used in the construction of the homes. A lot of those companies don't exist anymore, but there are insurance companies that carry the liability. And so you've got this situation where you have sort of known participants in the market, but we don't know which of those participants is responsible for any particular home's lead paint. And there are some courts that have engaged in something called market share liability, where they'll look at the 3 or 4 companies that occupied the market. They'll figure out the relative percentage of the market each occupied, and over a series of cases, allocate on a percentage basis based on market share respective liability. That creates some interesting puzzles in tort law. If you imagine, for example, some cases in which we don't have the information, so we allocate based on market share, but some cases in which we actually do know which painters were responsible. And then you have the question, well, does that mean that it's possible that 1 or 2 of the market participants is responsible for more than 100%, because they're being allocated when we don't know, but they're allocated a percentage when we don't know, and allocated 100% when we do know. And this is an unanswered question in the law. But as a general rule, the answer is that the allocation of relative fault among tortfeasors is a question that the fact finder is going to address, of course, subject to judicial oversight to make sure that it's reasonable given the state of the evidence. I hope that that's helpful.
Yes, indeed. It was really something that is going to enlighten us, and also at the same time agitating our mind to read more on this and understand it's better. I do consider that this analysis is very new, started from the half of the centuries back. The next question, Professor, it's something this part of the world is more deliberating upon. And whenever as a researcher of the law, me, and I'm sure that Ms. Neha would be agreeing with us, we do think that the role of economic interpretation of the law in a dispute resolution. And whenever we talk about the dispute resolution, we do consider about arbitration as an alternative dispute resolution mode that is coming to playing a game along with, you can say, a parallel game with the court establishment and such. With that, there is a very good questions that one of our co-participants had posted, that how is game theory impacting contract law, more specifically in the case where there is an arbitration clause, and if at all it has a relevancy, then it's really we are interested to listen about it. So
it's a fascinating question. All of these questions have just been terrific. So there's 2 separate points I want to make about an arbitration clause. One is they tend to be inserted in form contracts. People don't get to negotiate over these things. And this brings me back to the lecture that I was referring to earlier. It's very interesting. So people get upset that they're often stuck with an arbitration clause, which is embedded in a form contract that they entered into. For example, if you go on a cruise, which I've personally never done, but if you go on a cruise, they often have arbitration clauses, and then if something happens on the cruise that results in a personal injury, the people who have participated in the cruise discover that they're subject to an arbitration clause different from a judicial process that they may otherwise have anticipated having available to them for tort or contract or whatever it happens to be. And there's a literature about whether these form clauses that include arbitration clauses, these form contracts that include arbitration clauses, are normatively problematic because they tend to be somewhat favorable to the party that has drafted the contract, right? The big company against the individual. But one benefit is in sort of ex ante from the front end is that these clauses reduce the aggregate cost of providing the services, lowering the contract price. And that's the trade-off. Although individually, most people entering into contracts don't think of it at the front end. They don't think, it's not like they have the option to say, would you be willing to pay 5% more for the contract minus the arbitration clause? Rarely ever do contracting parties have a choice, and so an interesting thing to think about in terms of contractual freedom as individuals, which we all are, is, do you consider yourself better off in a world in which you are negotiating over everything, like in a shuk, like a market where you're literally negotiating over everything? Or do you think of yourself better off in a world with robust contracting in which you face a menu of contracts, but every one of those contracts is take it or leave it, right? Your choice as a consumer isn't to modify the terms. Your choice as a consumer is to walk away. And I think most people, if they think about it, would understand that they probably do better as consumers with the menu of contracts approach. But I will say that's not an answer that satisfies all of my colleagues in law who think that the form contracts systematically disadvantage purchasers a lot of the time. And this depends on one's faith in the sort of the robustness of markets. And that gets a little bit beyond the topic today. The other thing I want to say about arbitration or ADR, alternative dispute resolution, more generally is it's also interesting to think about the fact that in a game theory sense, when we talk about judicial systems, common law systems, right? Like in the UK, India, the US, there are two functions that courts provide. One is dispute resolution, which you can think of as a private good. And the other one is the creation of common law rules that emerge through the publication and dissemination of knowledge from the opinions that are published. And that's a public good, right? So judicial systems provide simultaneously a private and public good. Arbitration or ADR, alternative dispute resolution methods, provide the private good. They provide the dispute resolution, but they do so in the shadow of the law, meaning with the benefit of the public good part of the adjudicatory process. So it's kind of interesting to think about that modeling. And the other element from game theory you can think of is sort of a separating equilibrium. It may be the case that when we're not talking about contractually being bound to arbitration, but the elected decision of parties to go to arbitration or to go to court, there may be a separating equilibrium in which, when you have what economists refer to as an asymmetry of information, each side thinking it's more likely to prevail, but one side having maybe inside information not yet shared, that you may be more likely to find yourself in court when there's common shared information, and therefore lower stakes in the dispute resolution part of the case, you may be more likely to be pursuing an alternative dispute resolution remedy. And that separating game might provide some insight into the relationships between ADR and litigation.
Before I take the last question, I would like to say that we have paucity of time. Obviously, we are flooded with many questions. We would be mailing it to Professor, but respecting all of our time, we would be taking the last question of the sessions. The last question is also very interesting, and this question talks about little different from what we're discussing, but I think obviously your comment on this would be enlightening to all of us. It's saying that what is the nexus between game theory and competition policies, precising more the antitrust laws policies? Are there any implication arising out of the same? The participants wants to know that, is there any relationship between competition policies and game theory? Again, this is like you as antitrust regime in India is also extremely debatable and extremely emerging, considering the kind of economic growth both the nations is witnessing. So up to your comment.
Yeah, these are all fabulous. These are all just fabulous questions, and I'm happy to address it. I do want to be clear about my own limitations. I'm not an antitrust scholar. It's just not my field. I have the kind of knowledge of antitrust that somebody who's interested in economic analysis of law necessarily has, but it's not a course that I've ever taught, or an area of law that I've ever actually contributed to the literature, other than a short discussion here and there in the book. So I'll say this: I do think game theory provides a set of tools, along with price theory or sort of neoclassical economic theory, provide a set of tools that can be used to address competition policy and antitrust. This may not seem immediately intuitive, but I want to suggest that competitive markets are a benign prisoner's dilemma. What I mean by that is that not all prisoners' dilemmas are bad. Some prisoners' dilemmas are actually good. They can be good or bad, depending upon what you're trying to do. The classic presentation of the prisoner's dilemma imagines separating two arrestees, putting them in rooms and giving them incentives. And it requires an inability of them to communicate and to honor commitments. But there are other ways that we can functionally prevent communication and honoring of commitments, one of which is just big numbers of people involved in decision making. And that is competition. When you've got countless numbers of purchasers and countless numbers of sellers in a robust market, as a functional matter, the buyers and sellers can't coordinate among themselves, and therefore you are in a situation where they can't collectively coordinate and bind each other. And you end up benefiting consumers because we end up with a supply and demand configuration that gives consumers a considerable, what economists refer to as consumer surplus, which relates very much to the arbitration clause in contracts in the prior discussion as well. By contrast, when you are in a monopolistic environment, which is to say when one party is controlling the market, which is the concern, a concern of antitrust law, subject to a caveat that I'll get to in a moment, it is in fact the case that the monopolistic producer is apt to reduce the output of goods and services and substantially raise the price, producing what is referred to in the literature as a monopoly rent to the detriment of consumers. And this can arise in any number of ways, including, for example, what's referred to as a natural monopoly. Natural monopoly reflects the insight that for certain kinds of sectors, as the business becomes bigger and bigger, the average cost goes down over time, which tends to drive out competition. So, for example, utilities, electrical utilities, mailing services, and the like, the startup costs are so high that the bigger it is, the lower the average cost. It's very hard for other firms to compete, which is why you tend to see governments either regulating the prices that utilities can charge or taking over utilities sometimes and actually providing those services entirely on their own. And so that's one way. The other caveat point that I was going to get to is, it's not as if antitrust policy is motivated to prevent monopoly altogether. We see monopoly in a certain sense all the time. We see it through what we think of as product differentiation. So, for example, and I'll give a concrete example, right? Two leading manufacturers of cell phones, Apple, Samsung, right? There are others, but those are two leading manufacturers of cellular phones. And they're not identical, right? There are people who are kind of religiously devoted to Apple, and there are people equally religiously devoted to Samsung. They have slightly different features, and people who are in the market for these phones value the features that one or the other has, just like automobiles, right? There are all different kinds of cars out there in the market, and people are loyal to them, but they're loyal to them to a point, right? If you doubled the price of either phone, people would learn to love the other phone, right? But there's a limited amount of market power that these firms have. So we don't really have the classic pure monopolist, but we do see product differentiation that results in a degree of market power that results in some degree of rent. And what antitrust policy is largely about is not that. Like, we want to reward that product differentiation. What we don't want to reward is coordinated activity among sellers or buyers. When it's not the product of a superior good or service or the product of a natural monopoly, but rather it's a group of sellers getting together to coordinate, to restrict and raise the price, then antitrust law becomes particularly concerned, because then the consumers aren't benefiting as a result of innovation, which is what we want the market to produce. So that's kind of a bird's eye view. There's obviously more to be said about it. And as I said, this is not my core area by any stretch, but those are my general impressions about how you might think about the relationship between game theory, price theory, and competition theory or competition policy. So thank you.
Thank you so much, Professor, for your insightful views. And I am sure that the participants would have thoroughly enjoyed and would have gained valuable insight from this lecture. Thank you so much.
Well, thank you. Thank all of you for being so kind and for giving me the opportunity to speak to such a remarkable audience. I've really enjoyed it quite a lot.
Thank you so much, Soumya ma'am, for taking up the question and answer section. With this, we now come to the end of the session, and I would kindly request Ms. Neha Tripathi, Assistant Professor of Law, to deliver the vote of thanks.
Thank you very much.
With this, we now come to the end of the session, and I would kindly request Ms. Neha Tripathi to deliver the vote of thanks.
Thank you, dear. Am I audible?
Yes, ma'am, you are.
Okay. Good evening, all. Respected Professor Stearns, our most valued invited guest, ladies and gentlemen, it's my privilege to propose a vote of thanks on this occasion. On behalf of Maharashtra National Law University Aurangabad fraternity, I take this opportunity to propose a vote of thanks to those who have directly and indirectly contributed to the webinar on economic analysis and premises of contract and tort doctrine organized by our university. At the outset, my heartfelt gratitude to Professor Maxwell Stearns for accepting our invitation and addressing the gathering today. Professor Max, we are really enlightened with your knowledge and presence. We would like to thank participants for attending the webinar and asking such engaging questions. We are thankful to our Vice Chancellor, Professor KVS Sharma, for his support and motivation. I would like to extend my heartfelt gratitude to constant support and upliftment I received from a colleague and my dear friend, Ms. Soumya Raj Singh. A special thanks to the organizing committee and student team members of Center for Research in International and Comparative Laws. They need a huge round of applause. Teaching and non-teaching staff of the university for their unflinching support and coordination. Our heartfelt thanks to our students for active participation, and some of whom are worth mentioning here due to their enthusiastic and untiring efforts for making this webinar a huge success. Sulabh Gupta, Soumya Thakur, Simranjeet Kaur, Devansh Kathuria, Subneet Jha, and Kavya Singh. We look forward to host you for upcoming event by Center for Research in International and Comparative Laws, Maharashtra National Law University, Aurangabad. With these warm words and a kind message, we move to the end of today's webinar. I thank you all.
Thank you so much, everyone, for participating. And we hope to welcome you even in future with such insightful webinars. The video of this webinar will be uploaded on various social media platforms, for which the information will be provided later. Thank you so much again. Thank you so much, sir.
Thank you, everybody.
Professor Max, we are now going to end the session for today. Thank you so much for being here.